What is up? Good morning. Good morning. Welcome to Defense Diaries. I'm your host, Bob Mata, and a little impromptu live this morning. I was just opening my eyes, and Dizzy hit me up and said that good old Sarah Boone is in court this morning with her new lawyer. So I thought it'd be cool. I'm going to rewind it. We're going to go back, watch this thing for the beginning. I just have to see what poor sucker has gotten himself into representing this nightmare of a woman. It should be interesting. So yeah, I gave you guys no notice, so my bad. Hopefully you guys will trickle in. Hope everybody had a great weekend. We did a lot of traveling, a lot of driving. We did flew out to Philly. I'm just going to tell the story real quick. So Thursday night, late flight, because we wanted to make sure to make scouts volleyball game. She was very insistent, so I booked the latest flight that I could to Philly. Driving to the airport, it's me, Allie, Scarlett, and Cameron, our 18-year-old. We get to the airport, and I fly United typically, and I get to the airport, nothing. Like I don't get any texts. Like, so I'm assuming everything's good, because typically if there's a delay, they'll send me a text, be like, "Yo, your flight's delayed." So I get up there, and we're checking bags. So I scan my boarding pass, and a big red thing comes up on the screen, says your flight's canceled. I'm like, what? Oh, we're standing there at the bag drop off thing, and Allison's like, "Wah, wah, wah, wah." So she goes to the person working the counter, and she's like, "What? Like, try to fly us in somewhere else." They're like, "Everything's done. We can't get you a flight until 9:15 tomorrow, which PM, which didn't work for us." And we're like, so the woman ends up finding us a flight to Harrisburg, PA. I have a rental that was in Philly. I'm like, oh my God, we're not going to get there until like after the rental car place is closed. I'm like, what are we going to do? So we take the flight, which was that night. We ended up taking off around 10 o'clock. We get to Harrisburg. We have to Uber from Harrisburg out to my in-laws' house, which is about $120 Uber, which is fine. So we get there, and the whole thing was like a nightmare, because when we land in Harrisburg, they lost our luggage. So all of our bags are lost. So we're like, oh my God. So we don't have the luggage. I don't have the rental car. And ultimately, we end up making our way to New York City. It's our oldest daughter, who's getting married next summer, was going to Kleinfeld's, the famous dress shop with, say yes to the dress. Yeah, and Allie and Courtney used to watch that show when they were little, so it had a lot of significance to them. And I was going to sit it out. So it was my in-laws, Allie's best friend, and then, oh yeah, Courtney's best friend, and then Cameron. We're all going to sit in. Turns out that Randy, if you're familiar with the show, Randy was there with his private collection. Like Allison's texting me. I was walking around. I walked down to Greenwich Village and then turned around, went back and walked up to Midtown just to kill time. And so Randy was helping them. And ultimately, Courtney said yes to the dress. So it was very exciting. I didn't see it, so it was pretty cool. I'm going to be surprised. I want to be surprised. So I think it should make for a wonderful wedding day. All right. So let me pull this up. Just wanted to share that little nightmarish story with you that ended with a very happy ending. All right. Let's see. I'm going to go here. All right. Let's see what they got going on here. Okay. So I paused it right before Sarah Boone's walking in. Hopefully we get some volume. Wow, she just looks so happy. So happy. I mean, she's got to be excited. Wow, she's just, I mean, for a woman who's just staring at what she's staring at, sure is in good mood. All right, so I don't think we have volume yet. I mean, honestly, the judge has to be pretty happy too. Like the
Judge, I'm James Owens, and I'm representing.
There we go.
Sir, good morning. Pleasure. Ms. Boone, good morning. Could you please state your, raise your right hand now. First, going to go ahead and swear you in.
Do you solemnly swear or affirm that the testimony you're about to give shall be the truth, the whole truth?
Still sounds like it's sound sucks.
Ma'am, good morning. Could you state your full name and date of birth for the record for me?
Sarah Boone, 10-10-77.
Good morning, everyone. We are here on several different items. The first is the court's notice of hearing that was sent out last week. The first issue on that was addressing the viewing of the physical evidence here in open court. On August 5, the court entered an order setting forth certain deadlines and scheduling, including the viewing of the digital evidence no later than September 3, and the physical evidence viewing to take place here in open court on September the 3rd, and a schedule for objections thereafter. The digital evidence review took place on August 9th, and the August 23rd deadline for objections has since passed. On August 14th, the court was advised of an alternative arrangement and advised the state to file a notice reflecting when and where and how that review would have taken place. I did not receive or see such a notice in a court file. Mr. Cashore?
Yes, Your Honor. We were not able to file the notice prior to today. However, on Friday, August the 30th, we were able to have that evidence review of the physical items with Ms. Boone at the Orange County Jail.
Okay, all right. Ms. Boone, can you confirm if in fact that viewing took place?
It took place.
Okay, all right, very good. And who did it take place between the state, yourself, and was Mr. Lane with Prison Break Investigations a part of that viewing?
Correct.
Okay, all right, thank you very much. Also set for hearing this morning was defendant's motion for payment of costs and appointing neuropsychologists to assist the defendant in preparation of the defense that was filed on the 14th. The next day, August 15th, JSCS filed a response to the motions for payment of costs and appointment of a neuropsychiatrist. Paragraph 10 of the JSC's response reflects that the JSC will not be participating in this hearing. Mr. Owens, good morning. What is your position, sir, with regard to Ms. Boone's pro se motion for costs? Are you adopting that motion?
I'd like to abandon that one, but substitute it in for two other motions for the appointment of a forensic psychologist, Dr. Julie Harper, who was on this case previously. I believe she saw Sarah Boone about 6 times.
Wow, he's old. He's an old lawyer. That's super shocking to me. Super, super shocking.
In Orange County Jail. She was working under the direction of the original counsel, Mr. Padilla, who I believe had the case for about 2.5 years. And I think it was set for trial, ready to go, and then at the last minute, he withdrew. I tried to call him a couple of times, haven't been able to find out what went on. I have talked to Ms. Cashman, the last lawyer, but we don't need this neuropsychologist that Ms. Boone had requested, but we do need a reappointment of the forensic psychologist, Dr. Julie Harper. I've spoken with her a couple of times last week. I text messaged her 4 or 5 times this weekend. She is in agreement to handle the case, to reopen her file. She has sent me her records. I have reviewed them. I've met with my client. I think my client meets the criteria for that spouse. I believe Dr. Harper, after she gets a chance to re-engage with my client, spend some time with my client, and hopes that she's going to be of that opinion. In addition, I believe it's necessary for the appointment of a crime scene reconstructionist and death investigator, Dr. Michael Berkland, who is from
Thank you for telling me that I was muted. Yeah, I got a new mic. How does it sound? I had to get it on necessity because I had to record an ad when I was in Philly, so I didn't bring my little guy. I'm not still muted, right? Y'all can hear me now. Quit saying muted after I'm speaking. You guys can hear me now. Somebody give me a thumbs up. Anybody? All right, I'm going to assume that you guys can hear me. So this is interesting that he's talking about the battered spouse syndrome. That must have been a prerequisite of him taking the case. Like he had to say, hey, look, I'm not going to go in and get my ass handed to me. I have to be able to present a defense. And that's a problem because of what Sarah has said in her interviews, right? Like, I mean, she is denying that she meant to kill him. Like the intent is her big argument. And with battered spouse syndrome, you're basically saying you did what you did because he was battering her for an extended period of time. So it's interesting. It's interesting. And it really sheds some light on like why she was able to get a lawyer. She must have capitulated a little bit.
my area, Pensacola, is who I am recommending to be appointed.
What was his name again, sir? I'm sorry.
Michael Berkland. I filed these judges yesterday or last night. I don't know if they're in the court file yet.
I did not see them this morning. I did see the motion to dismiss.
Can I post them in?
Yes. State, have you seen them?
I just saw them briefly this morning prior to
Morning, sir.
the hearing.
Thank you. The only thing I saw in the court file, Counselor, when I was prepping last night was the motion for statement of particulars, the comments number 2. I have not yet seen these motions.
Judge, I also filed a motion for additional discovery. I don't know if that made it through as well.
Was that also filed yesterday, sir, sometime in the evening?
It was filed at 8:30 yesterday morning.
So I have your motion for statement of particulars filed 8:10 yesterday, but I do not have the motion for additional discovery filed 8:34.
I don't know why the court was not able to post that, because they were filed one right after the other.
One's in the court file, the other 3 aren't.
What, yeah,
They were all filed yesterday, 19.
no, certain things auto-populate and certain things have to be accepted.
Okay.
The statement of particulars and the additional discovery were filed yesterday morning. The motion to appoint the crime scene reconstructionist and death investigator and the motion to appoint the forensic psychologist was filed at 6:10 p.m.
I do see that. As the court previously identified, JCS chose not to participate in this morning's hearing by virtue of their response filed on August 15th. They're not here. Your motions for these various experts report they were sent to all persons on the service list through the e-portal. But I don't know how I can address these this morning without having JCS here. So I will endeavor to coordinate a hearing for these as soon as practical. I understand these need to be addressed. Be advised, this is a trial week for the court, as is next week, but I will do my best to endeavor to try to get these heard as soon as possible.
Judge, and I have, I filed my notice of appearance on Friday,
Yes, sir.
and I've spoken with Dr. Brooklyn 2 or 3 times this weekend. The state was able to provide me with some discovery. I think once I filed my notice early Friday morning, I think the state provided a lot of discovery to me. I provided that to Dr. Brooklyn. I believe he has the autopsy. We cannot find the autopsy photographs, which he says are critical. We cannot find the crime scene photographs, which he says are critical to his evaluation. So I know time is of the essence. We've got people working on it, but there is some additional evidence that we need.
State, what's the status of the provision of the autopsy photographs and the crime scene photographs and provided to the council?
We provided all of those things previously, obviously, to the defendant, which has been greatly discussed already. When Mr. Owens' notice of appearance came on the case, I instructed my assistant to go ahead and send copies of the document discovery, which is easily available to him, just so that he could quickly have that and not have to worry about getting that from his client or whatever. I believe we also sent notice to as well that if he wants additional copies of the autopsy and crime scene photos or
No, this is the state. Her lawyer is the older gentleman with the gray hair. Wow. I see it in the comments. Look, I think that, and I think you guys are accurate. I think that Sarah Boone realized in very short order that she was not up to the task of trying her own case. And I think that she will play nice with this lawyer because she has to realize, she has to realize at this point, this is it. This is it. That like, if she gets a guy who obviously had to have entered his appearance pro bono because he's private counsel, he's not a public defender. Remember, everybody that's been fired or removed in the past, they were all PDs except with maybe the very first one. I don't know. I wasn't really following her case at the very, very beginning, but maybe the first one was private, but this guy's private counsel. He's entered his appearance pro bono, meaning that she didn't pay him. She has to be very thankful. And I'm assuming that she's going to play very, very well with this lawyer because she can't afford not to. So, but this guy that we're looking at the back of his head, this is the state right here.
or any other pieces of digital evidence in the case, that he just needs to provide USB and he can go ahead and burn that for them. Again, this is in addition to what's already been provided to the defendant in this case.
Okay, do we have a time frame where we might be able to get that information to him?
But if he wants to come back to my office, we can do it this morning / this afternoon.
Sure.
Office in the building?
Yes, it's in the courthouse.
Right there. Come out the front door, make a left.
Okay. I don't have a USB with me, but I'll find one. This morning, we'll get that done.
Okay, I appreciate you both. With regard to the motion for additional discovery filed yesterday, September 2, 8:34 a.m., state give you the opportunity to review this.
I just reviewed it just now here in court this morning. The state was going to request an opportunity to respond to both this motion and also the motion to the statement of particulars formally and in writing, given the lack of time we've had to prepare to make a quick formal response.
Sure. And how much time, Counselor, would you like in order to file a response to the motion for statement of particulars and the motion for additional discovery?
I would ask for at least a week.
Any objection?
No objection.
Okay, all right. The state shall file a response to both the motion for statement of particulars and the motion for additional discovery no later than the close of business 5 p.m. on Tuesday, September the 10th. And if hearings are necessary, we'll coordinate those. With regard to the defendant's pro se motion for payment of costs and appointing neuropsychologist to assist the defendant in preparation of the defense, the court's going to deny that as moot based on Mr. Owens' representation. With regard to the motion to appoint crime scene reconstructionist and death investigator and motion to appoint forensic psychologist, State, are you intending on filing a response to these?
No, we're going to take no position on those points.
Okay, all right. I will have Ms. Barrios, I'll ask the clerk to see if we can push these through the portal today so that Ms. Barrios can reach out to JICS and see if we can get a time frame on when they may be able to provide a position statement or a response to those motions, and then we'll coordinate a hearing respectfully.
Judge, I'm going to want to add one other forensic psychologist, make a request. I want to make sure that there's not an issue about my client Sarah Boone and I manufacturing defense. And there's a second doctor, Dr. Michael Brandon. I'll spell that out for you, sir. Dr. Michael Brandon. I don't know.
B-R-A-N-N-E-N?
He spells it B-R-A-N-N-O-N. He was the forensic psychologist in the Marsha Thompson case. That was the Palm Beach County first-degree murder where she shot and killed her husband, shot him 9 times. He was laying on the couch. And
Wait, he died 9 times? Dude was a cat? That must have been a little bit of slip of the tongue there. So I text Jay. He says, thank you guys, and that he's missing everyone. So he's clearly at work, and he's missing us, and we're missing him. So I sent the message, y'all. I sent the message.
was acquitted of first-degree murder back in July of this year. That was a 2019 case, so that took a while to get to trial. But Dr. Brandon testified that a battered woman's experiences affect her perception of imminent danger. And that's going to be a question in this case, whether or not Sarah Boone, at the time of her actions, was facing imminent danger. In addition,
I mean, doesn't sound like it. Doesn't sound like it from her interview. Said they were having a great day. It was their best day in a long time. It was their best day in a long time. Doesn't sound like imminent danger. I mean, plus he's in a suitcase. I don't know. Yeah, it's a good question. I don't know who brought it up. I think it was Couch said something. I don't see the judge giving a continuance for this lawyer to get caught up, but hopefully that's addressed today.
Dr. Brandon said victims of repeat violence may fear death in situations others would not.
And
I've tried to reach out to Mr. Brandon this weekend unsuccessfully, and my intent is to reach out to him. I'm hoping he's going to respond. He claims on his website that he responds within 48 hours. That's the only other witness I'm going to need an appointment for a forensic psychologist. So 2 forensic psychologists, Dr. Julie Harper, Dr. Michael Brandon, and then the crime scene reconstructionist, Dr. Michael Burke. And then in addition, I would like Billy Lane, who's seated in the audience. He is the investigator on the case. Because of the claims that we're making, that she's a battered woman, We need evidence to corroborate that, so there's a lot of history between her and Torres involving the apartment complex, which is in Winter Park, that was 4 years ago. The ownership of that apartment complex has changed hands, so it's going to be somewhat problematic trying to get information about who all the tenants were that may have witnessed some of the violence involved in these two, as well as we're trying to get together the 911 calls that Sarah made and others made about the disturbances between that couple. So he's got a lot of work to do as it relates to running down witnesses. In addition, we're trying to get arrest reports of the prior domestic violence arrest of Mr. Torres, as well as the officers involved in their body cams to see if there's any evidence on the body cams that would show injuries to Ms. Boone. So we've got a lot of work to do, but I believe it's necessary for us to prove a viable defense of battered spouse syndrome, that we have cooperation. It's going to take a little bit, but I do need the appointment of that expert. He tells me he's already on. I'm going to have to file something else because it was under Sarah Boone. Now, as the attorney of record, I'm going to have to file something. He says he's still got plenty of hours to work under that original cap. So I'll be filing something today or tomorrow as it relates to that. But that's the only other, of course, I've been retained, so I'm not going to make any claims for attorney's fees. I'm not making any claims for travel costs, just for these witnesses.
The JCS has already approved, I believe, $10,000 in investigation fees and $1,000 for other costs associated with Mr. Lane. That was at one of our previous hearings. Now, that was when Ms. Boone was representing herself pro se. I can't imagine JCS may change their position with regard to those costs. They've already said yes, but file it and we'll try to tee it up for hearing as well to see if they have any position, or it can just be, the order can be modified to extend to you as counsel for Ms. Boone.
Thank you.
All right. That takes us now then to your motion for continuance file that was filed on August 30th. Court's had the opportunity to review that motion. Any other arguments or statements with regard to that motion? Mr. Owens.
Judge, I reviewed the state case law relating to continuances and the abuse, palpable abuse of discretion when the court does not grant it, but it is critical to my theory, our theory of defense, battered spouse syndrome. As you know, that takes time to develop, especially when the motion basically speaks for itself, but we're in a time crunch. Essentially, the trial is set for October the 7th. I have to provide a notice of intent to rely on battered spouse syndrome 30 days prior, which is September 7th, which falls on a Saturday, so I believe that gives me till the next business day, Monday, September 9th. But still, 6 days for Dr. Julie Harper to come back out and visit with Ms. Boone, coupled with this other potential forensic psychologist, Dr. Michael Brandon. He's not going to have time to do that. They've got to establish a rapport with her before they can run the testing, spend the time with her. And it involves some extensive history. Obviously, that couple was together for 3 or 4 years. I still haven't peeled back all the layers. I've tried to go through it, but as you know, something like that is going to involve several instances of domestic violence that did not involve law enforcement. That was just between the two. So we've been going through that. We're trying to get some medical records where she was stabbed by Mr. Torres in the leg, and some other evidence. It's just going to take some time, coupled with the fact that I've got to get Mr. Lane to get all this other objective evidence, witnesses, and 911 calls, and arrest reports, and provide that to the 2 forensic psychologists for them to help formulate their opinion as to whether she is, in fact, a battered spouse. In good faith, I believe she qualifies based on my spending 3.5 hours with her Labor Day yesterday, as well as the other 4 times that I've met with her. I have not spoken to Mr. Cordelia, but I believe that was probably going to be where he was going to go. I was not, involved. I don't believe you were involved at that time. I may have been.
Not me.
Okay.
My predecessor was.
But I think it was always ready to go. And for whatever reason, he withdrew at the last moment. And then here we are. But I think it's prejudicial if we're not allowed to present the defense that we believe we have a viable claim. And I would respectfully ask, I'm not asking for, I think most times you come on a homicide case, you would need at least 6 months. I'm asking for 1 trial cycle, 2 trial cycles, sometime at the end of the year or first of next year. I can be ready. I think that will give enough time for our experts to visit with Ms. Boone and formulate their opinions. I'm sure the state's going to want to take a deposition. I think they may have a right to hire their own forensic expert to go out and interview to see if they agree. But that's just going to take a little bit of time, Judge. I'm thinking 2 or 3 months, and we'll be ready to go. I'm not asking for a long continuance. The good thing about it is Mr. Padilla has done a lot of the work. My understanding he's taking.
All right. Now, if you haven't cheated and gone to Twitter and seen what the answer to this question is, this is it. So he's asking for a slightly short continuance, couple 3 months. Curious to see what the judge is going to say. I think that he's got to give him a little time. I think he's got to give him a little time. Like 2 months. 2 months is reasonable. Plus, for me, it doesn't butt up against Delphi. So if that would work, that would work for very selfish reasons. I hope he grants a continuance.
Just about all the depositions. I believe they've been transcribed. I haven't gone through all the discovery. She's got the 2 banker's boxes. She has not gone through all the discovery. We tried, but we have not made it. My understanding is a lot of the 2-hour interrogation with the sheriff's department has been transcribed. I haven't reviewed that, but we do have a problem with that interrogation. Now, that's why I made the request about the policy. Our policy in my county, San Jose County, is a little bit different. And based on my discussions with her, we feel like I'm going to need to file some motions relating to that. So, because of that, but ultimately because, yes, could I be ready for trial on October 7th? I believe I could, but not without the battered spouse defense, because I don't believe my experts would be ready. And so that's instrumental in our defense.
State, do you have any position?
I guess the state would just respond to a few things. Part of this battered spouse defense has been previously investigated with several Ms. Boone's previous attorneys, and in fact, the state did retain an expert, Dr. Tanya Warner, who's on the state's witness list in this case, in anticipation of a potential rebuttal of an attempted battered spouse defense. The state's position would be that we.
Yeah, Tina, real quick. Tina had said, but that's how she's using the system. Get an attorney, fire an attorney, fire. This could go on indefinitely. The difference is here is that those were appointed attorneys as public defenders. This guy is private attorney, private counsel, who has entered a pro bono appearance, meaning that she did not have to pay him. Look, I think that everybody in that room realizes that Sarah finally realizes that that shit's not going to work anymore, and that this is her last shot. I mean, the judge was so in stone. I'm not appointing a lawyer for you. I don't care. Like, he was not bending. Like, that was evident. So I think that the judge will take that into consideration. And if the state is being intellectually honest, they're probably not gonna beef too much about a short continuance, just because, look, no one wants to retry these cases again. And no one wants to have, okay, well, the guy asked for a short continuance a couple months. She's in custody. Where's the harm in that? Just to get him so that he's as prepared as he needs to be to go to trial. You don't want things getting kicked back on appeal because the judge refused to give a short continuance. So let's see what happens.
We would oppose a continuance at this time. However, the state's not opposed to setting another status hearing sometime next week, possibly, where we could address this and to see if there has been any movement, anything that would either change the state's position or potentially the court's position as well.
I don't think the state's thinking it through, Judge, because if we wait a week, I've got to file a notice of intent to rely on the battered spouse on Monday. We can't wait a week that the time has expired. If the judge doesn't continue it today, he wants to have a conference next week, but it's too late for him.
What's your response to the rule requiring these battered spouse or battered wife syndrome defense 30 days prior to trial.
You have to give it.
Right, but I mean, clearly when that rule was created, it contemplated that there would be sufficient time to prepare for that defense within 30 days of trial, which is why they gave 30 days, which is why the Florida Supreme Court said that 30 days, not 60, not 90, not 120.
But in good faith, you can't file a notice of intent to rely on the defense of battered spouse syndrome if you don't have a supporting psychiatrist, forensic psychiatrist, that makes that claim. I just can't say, hey, we're gonna rely on it, and I'm putting you on notice, I gotta have some kind of authority. I'm not an expert, I think she meets the criteria, but I'm not a psychiatrist. I'm not a psychologist, I can't make that opinion. I've gotta have an opinion from an expert before I can file that in good faith. I can't do it without Dr. Harper. She needs more time. Dr. Brand needs more time.
All right, thank you.
Good answer.
No,
Good
All
answer.
right, thank you very much. All right, Mr. Rhodes, it seems like you've already started diving into the case and what the court file has reflected. So clearly you've reviewed what is in the court file and the history of this case.
Yes.
I'm sure you've read the court's June 28th order, which was extensive as to the history of this case, multiple lawyers that Ms. Boone has gone through, the reasons for the non-conflicted out lawyers' basis for withdrawal, and why the court ultimately made a decision that Ms. Boone had forfeited her right to court-appointed counsel by her actions, or alternatively waived her right to court-appointed counsel by virtue of her actions. This case has been pending for some time. You advised in your motion to continue that you met with Ms. Boone on 4 different occasions, that you just met with her yesterday for 2.5 hours. You were aware of what the order identified, which was in paragraph 6 of the order in the judge portion, that trial specially set for October 7th, 2024, and that it would be not continued for any reason, absent extraordinarily good cause, and such extraordinarily good cause would not include the retention of counsel. You haven't been appointed in this case. When you undertook this assignment knowing that you were not being appointed and that by your own representation you're doing this free of charge on a pro bono basis and not seeking recompensation for any lodging or travel. You knew what the deadlines were for the court. With regard to any of the experts, there have been multiple prior experts in this case. You already identified Dr. Julie Harper, a forensic psychologist. You advised that she's met with the defendant on 6 different occasions. She was appointed back on August 3 of 2020 under Mr. Padilla's representation of Ms. Boone. At no point in time did Mr. Padilla file a Category A witness list disclosing Ms. Dr. Harper as a testifying expert, and as you astutely pointed out, this matter was days, if not weeks, away from being tried when Mr. Padilla moved to withdraw based on the reasons outlined in the court's June 28th order. Thereafter, Dr. Charles Heller, another forensic psychologist, was appointed on February 3rd, 2022, and again on March 1, 2022. No Category A witness list was ever disclosed with regard to Mr. Heller. Then Winston Hobson had an undisclosed expert that had met with Ms. Boone, as addressed in open court on February 9, 2024. As Mr. Hobson put it, that expert was not meeting with what Ms. Boone had desired or requested of that expert. There was another expert psychologist that was appointed by Patricia Cashman on February 28, 2024, who has expertise in battered spouse and or battered wife syndrome. There were also Dr. Linda Dore, 2 times sought to be appointed, once by Attorney Bankowitz. Dr. Dore specializes in battered wife or battered spouse syndrome. Once by Dr. Bankowitz Mr. Bankowitz, on July 17, 2023 again, by Attorney Hobson on January 1, 2024. Based on the Florida Supreme Court decisions in Middleton versus State, 220 Southern 3rd 1152 and 1176, Barlow v. State 221 Southern 3rd 562 at 569, there's a 2-part test determining the need of experts. We're not going to be addressing that today, as you sought to file these other motions that I haven't had really the opportunity to address. And JCS is not here to have the opportunity to review those. In Roberts versus State, 75 Southern 3rd, 1277, at pinpoint 1281, by the 4th DCA in 2011, citing to Lawson v. State, 884 Southern 2nd 540, also by the 4th DCA in 2004. In that case, defendant Ramos changed his defense counsel at least 4 times while this case was pending, with the latest change in counsel occurring 2 to 3 months before the actual trial date. There's no record evidence showing that any of Ramos's previous attorneys had provided ineffective assistance, and the defense had already moved for 4 continuances to prepare for trial. Similar to the Ramos case, Ms. Boone has played a prominent role in shortening the preparation time for trial, as set forth in the court's June 28th order. This case has already been continued 16 times. As of the date of your filing of your notice of appearance on August 30th, this case has been pending for 4 years, 6 months, and 4 days. On June 7th, this case was specifically set for trial on October 7th, and the June 28th order by the court specifically speaks for itself and evidences how Ms. Boone played a prominent role in shortening the time for preparation for trial when her 8th attorney, Ms. Cashman, withdrew. Ms. Boone reached the point where her right to adequate time for preparation and trial is counterbalanced by the right to the effective administration of justice. As of August 30th, when the notice of appearance was filed, there were 30.
All right. Now, just so you all know, I don't know which way this judge is going to rule. It sounds very much like he's about to deny it, right? Which he might. But there have been many, many occasions when Allison and I have sat in court and a judge kind of goes through just to make the record of the litany of reasons why they have to deny our motion, and then they've granted it. So while it seems very, very much, and he 16 continuances, it sounded like, which is an insane amount. So I don't know. I don't know which way he's going to go. I don't know which way he's going to go. It sounds like he's going to deny it, right? But don't be surprised if he says, notwithstanding all that, I'm going to give you a couple months. But let's see. He might be like, nah, you're done. You're going. Sorry.
37 days until trial commencing in this matter. Considering the prejudice of the denial, Ms. Boone has already availed herself to 4 different attorneys that were not conflicted out, Padilla, Bankwitz, Hobson, and Cashman, and only has herself to blame for the withdrawal of those 4 attorneys based on the representations in those motions and findings in the court's June 28th order. Discovery has been reviewed with Ms. Boone by prior counsels, as established by counsel's representations in various hearings, and prior counsel's motions for attorney's fees, all of which were filed in the month of August of 2024. Ms. Boone has had discovery in her possession since August 5, 2024. The digital discovery that the state seeks to admit at trial was provided to Ms. Boone on August 9. Although you are not court appointed, sir, the court's done its own research with regard to your expertise. You've been barred since October 15, 1986, with a duly elected public defender of the First Judicial Circuit in the state of Florida. From 2009 to 2012, you've tried over 100 cases to verdict throughout your career. You've met with Ms. Boone on 4 occasions, as outlined in your motion, not including the meeting that you had with Ms. Boone yesterday. As to the battered spouse syndrome defense, you still have time to file the appropriate notice in accordance with the rule. And considering all the factors as set forth in terms of the state 311 Southern 3rd 185 and pinpoint 189, 4th 2nd DCA 2020, your motion for continuance is denied. Matter, this trial is still set for October 7th. We will have pre-trial the 6th to 27th. Pre-trial in this matter, or trial case management will still be set for September 26th at 9 a.m.
Judge, a couple of things. Number one, I have a full practice. I've got a docket day this afternoon in Santa Rosa County before Circuit Judge Scott Duncan. I've got 12 clients that are pending. I've got other people covering it, but I do have a full docket. If we set some of these hearings involving my motions, could I be allowed to hear by Zoom?
Any objection?
No, Your Honor.
The only request I would have, sir, is the rules of general practice require a notice regarding your appearance. If you could just file a motion and provide a form order, I'll sign it and you can appear virtually. There's no reason for you to drive all the way down from Santa Rosa County for all these hearings when we can appear virtually. JACS, I imagine, will be appearing virtually for some of these motions with regard to the experts. So as long as you file a notice in advance, sir, I've got no problems with that.
Judge, in that pre-trial order, it mentioned, I thought, that the state attorney was supposed to meet with the defendant and the defendant's investigator and review all the digital evidence from the order. That's the way I read it. They were supposed to sit there all together and watch every potential video exhibit the state was going to intend to introduce at trial. That has not happened. I think today was the deadline for that. I don't mind extending that because I'm going to need to look at the evidence.
With regard to the digital, the deadline, you are correct, sir. The deadline was today, based on the August 5 order. If it did not happen before then, as I outlined at the beginning, there was a change to that process. A thumb drive was provided in open court to Mr. Lang on August 9. He then provided it to Ms. Boone, a thumb drive of the specific digital evidence that the state is seeking to admit at trial, based on the witness and exhibit list that was filed under seal on August 9. Ms. Boone had the opportunity to review that information at that time.
All right, I'm going to ask for more time for me to review the digital exhibits they intend to introduce. I don't know if they've been redacted, I don't know if they're originals, but I'm going to need to look at that. And I went to the jail yesterday, I had let them know in advance that I was coming. I believe my secretary had emailed them and said I wanted to bring in my laptop and my phone to view evidence and whatnot. I was not allowed to bring in my laptop and phone yesterday for 3.5 hours. So I didn't get done a lot of the things that I wanted to get done within that period of time. Probably would have stayed there a lot longer if I would have had that capability. So I would ask for some more time to be able to look, for me to look through the digital evidence as to what they're, I assume it's being redacted. I know some of the audio in terms of clients' comments the client made, comments the officers made, some of it is, in my opinion, improper to be presented before the jury. So I'd like some extra time to be able to do that.
State.
I'm not certain, is he asking for a continuous again? What is the extra time
Right.
that he's seeking?
Good point, State.
What is it you're asking for? Extra time to do what?
The way I understand the order, I'm looking at paragraph 4 of the scheduling order and notice of hearings that, Judge, you signed August the 5th. Paragraph 4, the state's digital evidence will be reviewed with the state's investigator, the defendant's investigator, no later than September 3rd, 2024. This evidence viewing can be done in advance of September 3rd deadline. The state shall provide the defendant USB drive with station. They never viewed it with my client in its entirety. As the order states, they were to do by today. So the state attorney has failed to comply with the court's order. I'm saying I haven't had a chance to view it either. Can we reset that deadline?
Yeah, it doesn't sound like he's asking for a continuance, just wants to reset the deadline of today. And that's on the state.
Mr. Owens, we had a different hearing. And at that hearing, we addressed the digital discovery review. Mr. Lang was here. There was a USB provided in open court, and the August 9 order and notice of hearing identifies a change to that August 5 order. Specifically in paragraph 4, prison break investigations by and through investigator Billy Lane shall take possession and custody of the USB jump drive, which contains the state's digital evidence, tendered in open court on August 9, 2024, and shall provide same to Major Malik X. Muhammad at the Orange County Jail today, August 9. Paragraph 6, prison break investigations shall file with the court a notice reflecting that the discovery in the USB jump drive, which contains the state digital evidence, was provided to Major Malik X. Muhammad at the Orange County Jail according to the date and time of the transfer. Such a notice was provided by Mr. Lane and filed in the court file. It was discussed at that August 9 hearing as to the revising of the digital evidence schedule. Paragraph 8 states that on August 14th, 2024, 1:30 p.m., a hearing will be held, courtroom 12A, regarding defendant's review of the USB jump drive, which contains the state's digital evidence. The defendant's August 7th letter to the court provided to the court on August 9, and the media's participation in the physical evidence viewing on September 3, 2024. The pertinent case law is attached. On August 14th, we had a hearing, we discussed that, and we identified that she had the deadline until August 23rd to make any objections. Now, under the original scheduling order, which said this matters, which on August 5, which set the schedule for when there would be deadlines for objections, those would be extended by good cause shown. Are you seeking at this point in time to extend the deadline for a period for objections which has since expired?
Yes.
Okay, state?
No,
Okay. How much time would you like, sir, in order to review the state's digital evidence that it seeks to admit into evidence and tender any objections?
I've got to go by, jump drive. I've got to take it down to his office. He's going to give me that evidence. Obviously, I need to review it with my client. I've got a flight out of here around, I think, 4 o'clock. I don't know if I can get it done by then, but I don't see the necessity of an issue, maybe a week prior to trial, whatever that is, a week prior to that Monday, October the 7th, the week prior.
State?
I'm gonna be amenable to setting a status hearing that week.
Here's what we're gonna do. We'll address any objections to any of the discovery when we have trial case management on the 26th.
Thank you, Judge.
All right. Anything else, Attorney Owens?
Give me 1 minute.
Sure.
That's
State, anything else?
not this time, Your Honor.
Madam Clerk, going to work dutifully to, it's already done? Excellent. I'll have Ms. Barrios, my judicial assistant, forward these to JCS and see if we can coordinate a hearing. State will have till close of business September 10th to file responses to motion for statement of particulars and motion for additional discovery. Parties have no other business before the court. You'll have a fabulous day.
Thank you, Judge.
Thanks, sir.
Can I have a word with Sarah?
Absolutely.
All right. So looks like they're done. All right. So that was interesting. That was very, very interesting. I'm not shocked at all that he denied the continuance. I don't know if it's the right decision though. I get it. I get why he did it. Obviously, the amount of continuances, the amount of lawyers that she's gone through certainly appear that she's jobbing the system, but like that argument always kind of like falls on deaf ears with me. She's in custody. Like jobbing the system in terms of, a client out of custody is something that happens because they're obviously trying to stay out of jail for as long as they can. Here, you don't have that. She's in custody. I get that the families want this thing to go to trial. The families of George want it to go to trial. But still, I mean, the fact of the matter is she's incarcerated. I don't know how much really matters that he's in prison or in jail at this juncture. She's been in for 4 years. Ultimately, if she's convicted, she's going to get transferred over to a prison, Department of Corrections. So I don't know. Like I've always kind of felt when you have in custody clients, if you need a little extra time, and again, I'm talking specifically not about how I feel, not about what I think is right. I'm talking about the appellate issue potentially down the road if she's convicted. So she did not get the Sarah Boone trial was not continued, Ed. New counsel asked for 2-3 months. Judge went through a very long laundry list of reasons why he's denying it, but he denied it. And she is going to trial as planned. And that is the order of the court today. So, but again, you guys, you can never forget about the appellate process. Like, this isn't trial is just one part of the process. The appellate issues that this could bring up um down the road are real. I mean, like, the judge is looking at this guy's experience and he's saying, you've been doing this a long time, but barred since the mid 80s. And uh, I think that you're up to the challenge. The problem is kind of in his rebuttal after he was denied the continuance. And then he said, well, for all these hearings, for these motions that I filed, can I appear via Zoom? He's got a full docket. I mean, that's the other part of being private counsel is that you have other clients. Now, all that being said, he knew all that when he decided to sign his name on the appearance form and enter his appearance on behalf of Sarah Boone. So, obviously the judge took that into consideration as well. So we'll see. We'll see. I mean, clearly based on the limited amount of time that we saw him today, he appears competent. He appears as if he knows what he's doing. He appears as if he's got some knowledge about the case. So those things he has going for him. Look, he's going to have to bust his ass for the next 20 days, 25 days, getting ready for trial because it's barring some kind of unforeseen situation popping up. I mean, this guy's going to trial next month, and that's it. So interesting. It was I had heard that a new lawyer had entered the appearance. I didn't dig into him at all. This was the first that I'd seen or heard of him. So I don't, I mean, the guy looks like this long into his practice. Like, I was always expecting if somebody was going to answer the call to the flyer, that it was going to be a younger lawyer trying to make their chops, trying to get a big case under their belt, get their name out there. Good, bad, or indifferent in terms of the result. You try a case like this, it's going to get you exposure. And, most people that know anything about this case feel pretty secure about the fact that she's going down for something. I don't know what it is. I think the intent issue will ultimately be kind of the bigger thing here. Like, to me, that's the most interesting thing about this trial. Whether or not it's a murder or a manslaughter. So, um, and I can't remember. Like, Dizzy, let me know. Was she charged with second degree? And then there's a manslaughter in there as well. Because again, and if you guys remember when we were covering, I forget what we were covering last week when I was reading through um, that state's version of premeditation, that it doesn't need to be like something that you plan days or weeks in advance. Premeditation can happen temporally in a very short period of time. So yeah, second degree murder. Thanks, Diz. So I'm sure within that there's a manslaughter charge involved as well that the jury can rest their hat on as well. But I think that ultimately at the end of the day, that's going to be the bigger argument here in terms of whether or not Sarah committed murder or she committed manslaughter. So, and that was kind of the argument that she was making when she was arguing her own motions, that, when she went upstairs, she just assumed that he'd be able to get out, whether or not that's true. Like, I don't know, I like, if I'm drunk and I go upstairs and I left Allie a piece of luggage, uh, I mean, she's going down on it. It's a matter of which way she goes down on it. But yeah, this case. So, but I think we're all relieved that as much as I kind of wanted to watch that car wreck that was going to be Sarah Boone defending herself, this is going to be a much better trial with an attorney involved, because the novelty of watching pro se defendants gets old quick. It becomes annoying to watch. So I think that we should all be very happy that she has competent counsel that will make the trial much more bearable to watch, because Daryl Brooks aside, like he was unwatchable to me. Like, I mean, I know he was obnoxious, and it was like you weren't watching the Brooks thing to, for the legal acumen that was being like bandied about. You were watching it to see the next time that guy was going to have like a mental breakdown in open court. I mean, it's two different things. So, um, yeah, hold on, I got to cough real quick. I hit the cough button, old school. This new mic I have, I can like boop. That's pretty cool. Oh God, yeah, that's what I'm saying, Pam. I mean, the Brooks trial was unwatchable. It's just awful, awful. So yeah, this is good in a lot of different ways. So that being said, as I'm looking forward to trial coverage, I've got some real issues going. I desperately want to cover Donna Adelson's trial. As we know, Jay, my brother from another mother, has started his first day at work today. So we all miss him dearly. We all wish him good luck on his first day. I hope that he likes his new gig. Um, and Jay will probably be doing nighttime stuff with that. I am going I leave, I think the day before Donna Adelson's trial is to start. I'm flying to London with the family for CrimeCon UK. So theoretically, I'm gonna have to miss the first. Like Dizzy was texting me. She's like, Bob, you're gonna be in London at the beginning of the Adelson trial. I'm like, oh no, what am I gonna do? So I'm gonna have to try to figure that out. Like I don't know. I don't know. Like I don't know what I'm gonna do. And then now we have the issue that Boone and Delphi are going to they're overlapping. Now we know that Delphi is not going to be streamed. I think that we'll be able to figure something out, whether it be Allie is going to stream Boone during the day, and then I come and do a Delphi recaps at night. I've got to talk her into that. I've got to talk her into that. So I'm going to need y'all out there in the chat to poke Allie, say, yeah, cover Boone while Bob's in Delphi. So theoretically, I'm going to have to sit there every day in court in Delphi. So I'm not going to be. What I'm hoping to do is maybe be able to talk Allie into alternating covering Delphi, where I'm in there sometimes, she's in there sometimes. It's not that long of a drive, 2.5 hours. So, yeah, Bobby, me too. Like I keep really hoping that something's going to happen with the Delphi thing where they're going to change their mind and she's going to decide to allow streaming, but I'm not getting the vibe. I'm not getting the vibe. It would have to come up from somewhere above her, Judge Gall, to convince her to do the streaming. Maybe the Supreme Court, but I mean, ultimately it's her call. So I don't know. I don't know. All right. So a couple other things I want to update you guys on. As of now, going live tonight with Bill. We are going to have one of the amazing mothers. So we're continuing our Guevara coverage, which we're probably going to be doing for probably the next several weeks with Bill. And tonight we are going to, I'm waiting to hear from her. One of the moms, one of the amazing mothers that fought and fought and fought and fought when no one else was to get her son out of prison. Blanca Gonzalez is supposed to be joining us. I have not heard from her to confirm tonight. Originally, we were going to have another one of the moms who had started one of the groups that fights to get justice. So that should be great. Getting a mom on there that has fought for her son's freedom for a long, long time, I'm sure is going to make very, very compelling streaming tonight. So that'll be 9 o'clock. I know that's late for some of y'all, especially our East Coast and those over on the other side of the pond. But I have to accommodate Bill as much as I can. He's still up at the crack, even at 9 p.m. for me. It's very early in the morning, still dark out where he is. And most people are still sleeping. Yeah, no, I know that, Deja. There's not going to be any live streaming from London, that's for sure. Yeah, I know. Like we're doing stuff. We're going to see things. like Saturday, Sunday, I'll be working. Well, I mean, she says no live streaming. I intend fully on doing some lives with Allie and I, just like kind of shorts, just popping in, saying hi to y'all, letting us know or letting y'all know. I'll have the mic with me just in case we need to go live for cool things that we're seeing and doing. We think that that might be a little fun. So, but yeah, as far as sitting there streaming trials while we're in London, that's definitely not happening. So I'll have to try to figure out Adelson. I don't know. I don't know. Man, I really want to cover that. It's like, it's tough. All right, and then a couple other programming notes. I fully intend on covering. I am very, very behind on Delphi. Not very, very behind, but there's been some movement. Nothing like mind blowing has been going on, but there's some documentation that I want to cover. So I'm going to do that. Before I do that, though, I very, very much want to discuss with you guys the Adnan Syed Supreme Court ruling that just came down last week. Of course, when I was traveling, it's how it always is with Syed. Like Syed always happens to. Seems like it comes like action on that always comes down when I'm out of town. Like always, every single time. It's weird. Kind of like Delphi. Delphi does kind of the same thing. Happens when I'm like not available to hop on. Sheila, I haven't heard anything on Avery. The Avery news, as far as our coverage, I am hoping that the second season of Avery is going to be starting in probably about 3 weeks. Because we decided to break that down. It's that the Avery coverage is going to be very lengthy. I was not about to suck myself into like another one season of 60 episodes. So we are going to break that down, probably 10 or 11 episodes per season until we get through everything. Because if you know, with our Avery coverage, we're truly doing a deep dive. Like we're reading everything and we're going through it with everybody in our podcast. So, and that's podcast only. So if you guys don't listen to the podcast, people seem to really like our coverage of Avery and are like, where's the rest of it? So like, there's that. But yeah, Avery, we have not forgotten about Avery. I would never do that to y'all. I'm just trying to get my shit straight. Like I've got to like finish one thing before I move on to the next thing. So I get excited. I'm like, squirrel, but I'm not ADHD. That's the thing. Like I'm really not. It's like but there's just so much to cover. I just have to kind of decide, okay, this is what's important to me to cover, and that's what I want to cover, and I'm going to have to let everything else fall to the wayside. Did he do it? Did he do it? That's right. That's right, Mia Bita. That's Avery. That's Avery. Plus, I want to do a little boots on the ground with Avery too. I got to make my way up there. I got to try to talk to some people. Yeah, I'm pretty sure I'm not spit. I don't have a problem focusing on things, but like I said, there's just a lot to cover. A lot to cover. So and I want to try to cover it all, which Spitfire, one of our ride or dies here, has been really sending me some great, great ideas about incorporating some of y'all on the team. We've already got a huge amount of mods. Dizzy is my absolute ride or die. Mandy is waiting in the wings. She's been dealing with some of real life stuff, and we're hoping that we're getting her back soon. But she gave me some really, really, really good ideas about things that I can do to incorporate you guys, the Armada, into helping me, kind of streamline stuff and helping take some of the work off my table. Because you guys, the streaming is the easy part. It's everything that goes on behind the scenes, which is where all the work is done. I mean, I could sit here on lives and talk to you all day, every day. I'm a yapper, so that's not an issue for me. And as long as I'm somewhat familiar with the case, I'm going to be able to pick it up. So that is not the issue. I want to be able to have graphics. I want to be able to have charts. I want to be able to like kind of that pre-production type stuff. I'm going to basically kind of put like a little want ad, a little bit of a want ad out there to the fam here to see if anybody wants to help Dizzy and I and Mandy and our kind of our core team and all of our mods. And I realize people have busy lives, but if you've got a lot of spare time, and Dizzy is a machine. There's like no one like Dizzy. Like I've said it last week and I'm going to repeat it again. I don't know when she sleeps. Like honestly, like the amount of modding she does alone, and then the tremendous amount of work that her and Tracy put into Seeking Justice is unbelievable. And then she's doing my thumbs. Like she does everything. It's like she's unbelievable. When I say she's the best, I mean that. Like she's unbelievable. Like I couldn't. You guys saw what happened last week when Dizzy couldn't log on to StreamYard. You saw in real time how brutal that was. So because that like I didn't have that. Like as soon as I see Dizzy pop up backstage with me, I always have just a nice feeling of calm just come over me, and I'm like, oh, thank God Dizzy's here. So last week I can't even remember what I was covering. Oh, it was one of the hearings, whatever hearing I covered. I can't even remember. But I couldn't find the stream. I'm panicking, so the whole thing was like, so it's a long way to say thank you, Dizzy. I like to thank Dizzy publicly, because I want her to know how much she means to me and Allison. She's amazing in every single way. So yeah, if you guys, I want you to kind of think about if you'd like to join the team. At this point, you'd be donating your time. Who knows in the future as the show grows? But we're definitely looking for help for avid trial watchers that may want to put together kind of little templates for us on trials. And also the other thing that I want you guys to and just know that I do have a lot of people coming at me, not necessarily on our in our YouTube family, but from all areas. Remember, my podcast is really my big thing, but I've got people from all over, all angles coming at me, wanting me to cover their loved ones' cases, whether it's missing persons, unsolved cold cases, whether it's wrongful convictions. I've got a lot of people coming at me, and I've made some commitments on a couple of them that I'm definitely going to follow up on. But if you guys have cases that you want Allie and I to look at or cover, let us know. Let us know. Dizzy will throw our best email up there. That's the best place for you guys to get in contact with us. And then Dizzy and Mandy typically screen those as well to make sure that they're legit. So if you guys want to get word to us, that's a great way to do it for cases that you want us to handle. So in terms of scheduling today, Allie went to go pick Nanook up. We had to put him in with a boarding place for a few days. We desperately miss our dog. We couldn't get him last night because it was a holiday. So she's on the way to get him. He'll be making his appearance here, and he'll be very, very mad at us. Last time we boarded him, he was very angry. He was very angry, very pouty. It took him like 2 days to get unangry, and like a really, really good walk from me. And he started to warm a little bit. So I fully anticipate he'll be giving me a lot of side eye today. I'll have to be giving him lots of neck hugs and kisses and all that good stuff to get him. So he's not, is he with you, babe? He says he's not missing mommy. So that's good. All right, good. Maybe he's excited. All right. That's a good sign. That's a good sign. I'm assuming she's already on the way back with them. So, all right. So I think what I'm going to do is Dorsch tonight. Dizzy will keep an eye out. Like there was a trial she was talking about starting, and it was with that awful, awful woman who, I can't remember like who I think she killed her husband and like buried him in the backyard, and then she blamed her daughter. Like just another terrible person who did terrible things. And like, I think that I have enough that I want to, yeah, Lori Shaver. Thank you, Dizzy. I think I'm going to pass on that trial because I think that we have enough to do to keep us busy this week. I want to do a daytime live on Syed, and I'm looking at tomorrow for that. The decision came down by the Maryland Supreme Court. If y'all don't know, I'm just going to give you the overview. Um, and if you don't know anything about Syed and the Adnan Syed case, that was the base. That case was the base of Serial, the podcast, which was really the podcast that got me loving podcasts was Serial when I first listened to it. And I wasn't like the minute it came out, I listened to it. It was like 2 years after it was out. People kept talking about it. I'm like, what is this? So I listened to it, fell in love with podcasting. I love that long form story type vibe, and that really drew me into it. So I always give Serial the credit as to why I'm in podcasting. But that case has been, it's just one of those cases. It's been one of those cases. And ultimately, Syed, and I'll give everybody when I do that live, I'll give everybody like a short background of the case. The victim was Heyman Lee, who was Syed's girlfriend. They were both still in high school. And Amanda, I'm not going to answer that question now, but let me say I've listened to the prosecutors. I've listened to their emotion-driven coverage of that, and Alice's closing argument, which had nothing to do with the evidence, but was really what I'm always saying shouldn't be involved in the law, but was emotion. Like there was an emotion-driven closing that Alice gave, where she put herself in the place of Heyman Lee and what she might have experienced that day. In terms of what happened with the Supreme Court, had nothing to do with the question of innocence or guilt. So, but ultimately, what ended up happening was that Marilyn Mosby, who was the former state's attorney of Baltimore County, she had decided, and I don't know what her rationale is behind it. I don't know if it was that she wanted to take a big swing at something before she left office. I did listen to Megan Spitfire. I listened to Bob's coverage. Yeah, I was supposed to do a like where I was moderating between the two of them because Bob couldn't help himself. Bob was firing, and he was going hard at those two. With like a lot of name calling and stuff like that. And it was, if he, Bob gets emotional about stuff. So, I can see how it's hard sometimes to not name call, but you just have to really lock yourself in on not doing that. And it's, oh yeah, Loner and Amber. It's a good. So that's what I was kind of getting at. So at some point, I don't know what her true motive was, Mosby, but they dug back into Syed for a year, and they came to the conclusion that they did not trust what happened at trial, that they didn't feel that they could trust the conviction, and so in Maryland, they had created a statute because, believe it or not, that there is in many states in this great country of ours, there is not an avenue for prosecutors to turn around and say, oh yeah, hold on, I have to cough. For prosecutors to turn around and say, yeah, we made a mistake. We want to vacate the conviction. So like there's not a statute that exists for that. So I know I've told you guys to watch this show that was a David Simon show that was on it, that is still on HBO. It's a 6-part series, scripted, but based in reality, called We Own the City, which was all about the gun trace task force in Baltimore, which was this rogue outfit of cops that, like, they come close to Guevara as being the most horrific cops ever, but they were so bad that they couldn't, like, there was like a hit list of cops that they could not call in trials because they were untrustworthy. So, like, it got to the point that where there were so many corrupt cops in Baltimore that the state's attorney wasn't able to call cops to the stand because they had so much shit in their background that the defense was going to destroy them on the stand. So because of the massive amount of frame ups and bad convictions that came out of that, they literally drafted a statute in Maryland that allowed for the prosecution to file a motion to vacate a conviction, which is exactly what happened in Syed. They did a year-long investigation. They dug up who they thought were a couple of other viable suspects. And ultimately, they went into court and vacated the conviction. Therein lies the rub, because what happened there is that they didn't give Heyman Lee's family, her brother specifically, who's the contact for the family, who's really advocating for the family at this point, really didn't give him much notice. They didn't give him notice that they were investigating it. They didn't give him notice that this was coming down the pike. They basically told him after they had made the decision, look, the guy that we all told you, law enforcement and the prosecutors told you is the right guy, we now think it's the wrong guy. And so they give him, I think, 1 or 2 days notice that they were going to be doing what they were doing. And then he's like, wow, okay, well, I want to be there. He lives in California. This is in Baltimore, all the way across the country. He's got to make arrangements. You can't just like jump on a plane and fly out to Maryland. He wants to try to digest what's going on. So at any rate, he goes and hires a lawyer. And then the lawyer, first thing the lawyer files is for a continuance of a week, 7 days. That was it. 7-day continuance. Now, I've said this in our Syed coverage, which has only been about the post-conviction work and everything that's happened prior to the case. I haven't done a Syed did he do it type season on our podcast, and I probably never will, because I'm on Avery. So ultimately, the judge denies the 7-day continuance. Just kick it 7 days. I mean, Syed had been in prison for 20 plus years. If I was Syed's attorney, I was like, yeah, like I go to Adnan and say, look, man, like this is Hayes' family, right? Let's give them a week. Like you've been, what's another week, right? I mean, I get it that you want to get out. I get it, but let's give them a week. And that didn't happen. And the judge said, well, you can appear via Zoom. And from that decision, this thing turned into a nightmare. From that decision, that like this entire issue that has been in front of the Supreme Court of Maryland has nothing to do with guilt or innocence phase of this. What it has to do with is victims' rights, the victims' families' rights, their right to be present at substantive hearings, their right to be able to meaningfully participate in those hearings. And what happened on last week, which I was afraid of, in terms of Syed, was that they were going to agree with the appellate court, and they reversed it. So now he's a convicted felon again. They vacated the vacation. They reversed the vacation of the conviction. So he is back to where he was. Now they've, of course, given them the opportunity to go back and redo it. this time giving proper notice. But here's where it gets weird. Mosby's not in office anymore. So I don't know what's been talked about back channels in that case, because when you have a new elected county or state or whatever you call your state's attorneys, if you've got a new one in office, he may not, or she may not, and I think it's a he in this case, he may not feel the same way about Syed's case, and he doesn't have to bring that forward. So, I mean, that's where it's at right now. No, he's not back in jail, Amanda. He's not back in jail. But I mean, I wouldn't be surprised if what he's going to try to do, I'm talking about the new, well, he's not back in jail, Megan. Like he's out. He's still out. The way that I kind of see this thing going, to be honest with you, or it's certainly a way that it could go, is I would not be shocked to see the state come at Syed and his team with a Alford plea agreement. Say, look, well, we want you to plead out to this, but we're gonna to basically do what they did in the West Memphis 3 case, where they make an Alford plea offer, where he pleads guilty to it and says that, I'm maintaining my innocence, but I realize that the state has enough to convict me if it went back to trial. Because if the new state's attorney does not agree with Mosby, he's under no obligation, I wouldn't think, to bring that thing again. And I'm talking about the motion to vacate the conviction, because now it's gone back in time. It's as if we've gone back in a time machine and moved it back to before them filing the motion to vacate the conviction. That's where we're at in this stage. So it's interesting. It's interesting. So it'll be a good live. It'll be a very, very, very interesting live. Yeah, Michael Peterson took one. The 3, Damian and Jason and those guys took one in the West Memphis 3 case as well. So yeah, and I think I'm going to do the live for Syed tomorrow. I will give you guys much better notice than I did today about going live. Dizzy just kind of I had just opened my eyes. So I will definitely give you guys better notice as to when that's going to go. But tonight, 9 p.m., I'm going to make the live here in a little bit. Join us for Bill and I. Again, I keep sniveling and whining about you guys watching this stuff. It's really, really, really good streaming material, and it's new. It's not something that you guys have heard over and over and over. I realize that people are interested in certain cases and invested. Yes, do that, but don't be afraid to get invested in other things as well, especially something that you haven't heard of, especially something that is so unbelievable. It's just unbelievable. It's an unbelievable story. This cop, Guevara, put 57 innocent people that we know of in prison on murder charges, and they've done lost decades of their lives, and 44 of them have been exonerated thus far. So this isn't maybe he did it. It's he did it. He was putting innocent people in prison on murder beefs, and it's unbelievable. And so we're going to have tonight, we're going to have one of the mothers who's fought to get her son out. And they're unbelievable stories. So we hope that you guys will join us tonight. Thank you we had a great crowd in here today. Thank you for Mia Bito gifting us the 5 DD memberships. We always appreciate that. Thank you for the $10 holla from Chris 10. We appreciate you. We always appreciate supporting the show. It's how we keep going. You guys help us massively with your support, and it lets us know that you appreciate what we do over here. So we're always thankful for that. Dizzy, of course, I love you. Thank you for everything you do. Mods, thank you for everything that you do on a daily basis. You guys are the best. And fam, you guys know I love you. Aw, family hugs. You guys are the best. I will see you tonight, and I look forward to it. All right, you guys. Thanks for the hang. It was always it's always good to watch Sarah Boone be weird, inappropriately smiling, doing weird shit in court. She's got a new lawyer. She's got a new lawyer. See how that thing goes down. All right, y'all. Thank you. See you tonight.